We are going to wait till about 8:03 to allow any last people to be admitted or to join the room. For those of you who are joining, we're waiting for people to join in the chat. We'll get started here in a moment, okay? All right, we are in the process of loading people who are joining the conversation. We will get started once the majority of the people are in with questions and answers. The agenda is posted on the board. For those of you who are watching or waiting, you can view in the chat. The chat is we'll show people coming and going as we go. And we're going to try to monitor the chat for discussions. All right, as people are making comments about the audio, and what we're going to do here is make sure that you guys can all hear me clearly. And if anybody is unable to hear, please check the sound on your end. Most of the messages that I am seeing now seem to indicate that I can be clearly heard. All right.
Yes, Dan, I'm confirming you are coming in loud and clear. It sounds great. Thank you.
Okay, excellent. So we're going to just because we have 240 participants currently, we're going to wait till more people get in the room. Because of the size of this group, what we're going to be doing is we are going to be addressing the questions. It cannot be a debate with this number of people. I have committed to staying on until midnight to answer any questions, or if the conversation ends, I'm here for the duration. We will take a 5-minute break at 10 o'clock so everybody can get a drink and use the restroom, and then we will continue further from there. So I'm going to get started with an opening prayer. I want to first read some scripture. 2 Chronicles 7:14 states, "If my people who called by my name humble themselves and pray and seek my face, turn from their wicked ways, then I will hear from heaven and forgive their sin and heal their land." My people, as I clearly understand this, are the people who believe and follow Christ. This scripture is basically referring to people having to humble themselves, pray, seek God's face, and turn from their wicked ways. This is a call to the believers. This is not to the unbelievers. It is our responsibility. And I would like to offer the following prayer. Lord, on behalf of all of us who believe in you, we repent for our failure to stand for your word in truth and in public, pledge to seek your face. We submit to your will and ask you to heal our land. In Jesus' name, amen. So I'm going to get started. I'm going to make some brief comments on the topics. And if you want to make a comment, these comments are available. When I open it up for questions, what we'll do is we'll try to respond to them in order. I don't care if you're for Karamo or against Karamo administration. I'm going to answer the questions and try to do the best that I can to answer them in order. What the format is everybody gets to ask one question, and I will give an opportunity for a follow-up. And if 240 people ask a question at the same time, it's going to be impossible to track this. So different people are interested in different issues, so we're going to do it by topic. I will make some brief opening remarks and then ask for comments or questions relating to topic one. For those of you who wish to post your agenda, either in support or against the position, this is not the forum. You can feel free to continue to use social media, talk to the news, or however you wish to do that. Today is to allow you to have an access to ask me questions about the role that I have with this party and to address the lawsuits and issues that we're involved in. So moving into the first topic, and this is the Trump ballot lawsuit. I got a significant number of emails, both in support and against the fact that the Karamo administration, Christina, was able to get 11 chairs from other states to join into filing an amicus brief, not on behalf of a candidate, but on behalf of the fact that the Secretary of State has no role in determining who is the Republican nominee on the primary. As you can remember, the Democratic Party moved up the lawsuit. They moved up the time of the primary to February 27th, resulting in a penalty from our delegates would have gone from 55 delegates to 16 in a settlement that was worked on by the state committee and the policy. We were able to split the awarding of delegates. So 16 delegates are awarded by vote at the early primary, and the other 39, which were rescued, will be awarded at district conventions on March 2nd. However, the question became would Trump be on the primary ballot? Now, they don't have anything to say about the district conventions, and there was a lawsuit not filing against the party, not filed against Trump, but filed in both the Oakland Circuit Court and in the Court of Claims. The Court of Claims is a special jurisdiction court for when you sue a government entity involving the state. And so because the Secretary of State was the named defendant, it was brought in the Court of Claims. This lawsuit then had Trump tried to intervene in the Court of Claims, and he was told he could not intervene because he was not a state defendant, but that he could submit an amicus brief. Our team had, with Karamo at the lead, had identified this as an issue where it was the Democrats trying to repeat what they did to the 5 Republican governor candidates and control access to the ballot through the Secretary of State. And so we were successful. Christina took the lead and was able to locate the American Center for Law and Justice, who agreed to write an amicus brief. They needed local counsel, and as general counsel, I assisted in that brief and submission. As you are aware, we not only won at the Court of Claims, I was there for the oral argument along with the Trump team, but then we went to the Court of Appeals where we filed another amicus brief. We won, and then the Supreme Court declined leave. What you do not possibly know unless you followed this closely, that this was a significant issue. As you well are probably heard by now, that this was a multi-state attack on ballot access by the Democratic Party to control access to the Republican Party. And as a result of Michigan, the coalition, it was so clearly decided that we won at the Court of Appeals 3-0, and we won at the Supreme Court to the point that they didn't even have a majority of the justices say that it was worth taking up. So this is one of the things that consumed a significant amount of time. There's a lot of background information that a lot of you do not see and hear, and this is stuff that involved Christina Caramo, myself, Jim Kopis, and others that were working on this ballot access issue. Once again, it is not about a specific candidate. It was about whether or not the party has the right to control access to the ballot, and that's what was determined. The party does. A little bit further down, we're going to review the statute of MCL 169-211, and it defines what a political committee is to do, and that is to control access to the ballot. So those are my opening remarks for those who are curious about what that was involved in, and this is something that we've been working on since the election. I have chosen not to include in my remarks the support that we've provided to the Oakland County recount. That's a separate topic and is outside the scope of this, but I can assure you that that is something that I was directed to assist and monitor, and the election subcommittee led by Dr. O'Halloran and worked on by Lori Skeeble and Braden. A lot of them have put a lot of work into that, and what we have in that situation, that is something that has consumed some of my time and role as general counsel. The second thing I want to talk to everybody about is the Hillsdale County case, and I'm going to give this to you in the form of an overview. So what happened in Hillsdale County was that there was a dispute prior to the Caramo administration. After November 2022, there was a dispute as to who was the recognized chair in Hillsdale County. Ron Weiser made a determination, and it was appealed at the February convention, which later elected Christina Caramo as the chair of the party. That delegates convention, which was around 2,500 people plus alternates of the delegates, made the determination as to who would be recognized. In discussing with Chair Caramo, we took no action. We were never asked to intervene or to make a determination, nor was it our position that it would be our role to adjudicate that, and we felt it had already been determined by the convention, which is our rights under the Height-Manis decision out of the Sixth Circuit, that the state committee had already ruled on the issue. We took no actions. We did not say yay. We did not issue a press release. We did not do anything. So at some point, there was a determination by a judge who intervened into the county party and made a decision. That judge then issued a decision that said that anybody who was acting in concert with the losing chair would be in violation of his court order. To act in concert means that there's typically the elements of that are that there's an agreement, and then subsequent to that agreement, there is some action that is taken. Again, the party took no action subsequent to the April ruling by the judge as to his determination and opinion as to who was the county chair. The state website that we inherited under Christina Caramo had already been adjusted with the results of the February convention at the time we took over. The Caramo administration did not adjust the links to the party, the county party website, nor did it get involved in saying which side was to win or which side was to lose. We took the position that it had been determined by the convention. We were summoned to court. We filed a request to dismiss because the court lacks what I call subject matter jurisdiction, and secondly, that we were a non-party to the lawsuit. Those issues were briefed. The judge ruled against us and made a determination that he had the authority to resolve the dispute. Chair Caramo, myself, John Smith, and others who were present for a one-day hearing listened to the testimony of Brent Liniger, who testified. He was cross-examined and asked questions. The focus of my questions was whether or not he had any evidence that there was discussions or agreements between the state committee subsequent to the April date. Those answers were in the negative. There was no evidence that there was any discussion or concert to act in, and we have asserted that there was no action. The judge's ruling, which came out over the period of time of Christmas break while I was out of town, indicated that he had made a determination that we were in civil contempt, fined the party $500, fined Christina Caramo $500, fined two other people, including John Smith, $500, and then stated that we were responsible for attorney fees. We are going to obviously be continuing through the process of evaluating the cost benefits of filing an appeal. Obviously, it will cost much more than $500. There's some legal ramifications of doing that. I disagree. My opinion is wholeheartedly that the party took no action and that the court has no subject matter jurisdiction. Our choices to review that decision are to file in the Court of Appeals or to go to federal court. That is a consumption of legal resources, time, and energy. So that is a matter that is still breaking. In fact, I have not even been served with the answer from the court. We called and made inquiry because typically when the court has a ruling or opinion, it mails it out to the party. I've appeared as counsel on behalf of Michigan GOP and on behalf of Christina Caramo and have not received a response. I've received a copy of the decision that was forwarded to me from John Smith. I've reviewed it, and I believe that there is legal grounds to continue to contest that issue. The third issue, by the way, that case was argued months ago, and the timing of the release of the decision, of course, is, shall we say, convenient. The third topic that I want to give you all an overview on is the Ingham County lawsuit regarding the trust and CoAmerica. And the first question I want to answer for those of you who are not aware of the different types of pleadings that can be filed is that courts have the ability to issue declaratory relief, equitable relief, or legal damages. And declaratory relief is where you are not suing and saying somebody is wrong. You are asking the court to resolve a dispute, a factual dispute. So since the Caramo administration came into the authority in late February of 2023, we became aware of certain things and certain disclosures. Included in there was a claim by CoAmerica that in 2022, Paul Cordes, on behalf of the party, had signed a note increasing a debt limit to the party to $3 million, which had previously been $2 million. The paperwork from the bank shows that that note was secured by the Seymour Street real estate. So we, of course, when the party received access to the records of the party, there was zero digital information. QuickBooks had been deleted. We were told that the data that had previously contained on the server was owned by a former chairperson, and he would not allow us access to this server. And there was no cell phones, there was no computers, not a single laptop, nothing to get a hold of. There was some licensed accounts. And so as a result, we had some filings which were public records, as well as filings that were given to the bank. And this is going to be important as far as the records that CoAmerica gave us. So at some point, the bank was induced to loan up to $3 million to the party, of which no individual had signed security according to the bank, but they had a security against accounts held at the bank and a security pledge against this building. In discussions at budget committee meetings, it was determined that the bank had said that they were going to take action against the building. This was not the Republican Party saying, hey, we want to determine what our interest in the building is or anything. The bank said they were coming against the building. At one point, Joel Studebaker was involved in the discussions. At a later date, Jim Kopis was. I was involved in those discussions, as was Chair Karamo. So now we get a copy of the promissory note, which is attached to the lawsuit. And interestingly enough, in that promissory note, it makes reference, and the promissory note is the agreement for the debt and the repayment, that the note is supposed to be paid. And it was interpreted in a meeting that Joel and I were present at by CoAmerica that it was supposed to be paid by December 31st of 2022, or we were in default. Now, I personally did not attend the state committee meeting in December of 2022, but I have been told by numerous witnesses that it was represented at that point that the party had no debt. I know that Mr. DePerno has issued a letter saying that the chair candidates were briefed that they were coming into debt. And it has been an issue that we have addressed candidly, that as a grassroots party, we can raise money to pay off the Weiser debt, which was from the 2022 election cycle. I've asked the party how they wanted to address it at state party. I suggested that everybody throw $25 in, that we quote unquote tax the delegates and settle the Weiser legacy debt. It was decided by many people that they did not want to ask for contributions of the delegates, that it would be the sole responsibility of Chair Karamo to go out and raise money while the party is, 1/3 of the party is viciously attacking the grassroots administration that was elected. And so no resolution came out of the budget committee. It's been brought to the state committee floor asking how to address this debt, and ultimately you can't do anything with the debt. And people have to remember that this is not a debt that the Karamo administration has. The Karamo administration has raised more money than the Karamo administration has spent. Chair Karamo has cut expenses on staffing. She's used volunteers. For example, those people who think about Mackinac Island and want to talk about Mackinac Island, this leadership conference had real discussions with speakers, and there's complaints about how much money was spent on speakers. Just to give you some perspective, Joel and I negotiated with Mackinac Island related to the way the conference has been run in the past, and we received the bills that were left over after the party had paid for in the last two leadership conferences at Mackinac Island. And I can assure you, we have documentary evidence that the liquor bill that was left after the lobbyists had paid off and the party had celebrated on Mackinac Island exceeded the amount that the Cromwell administration spent on speakers. So yes, it is true that agreements were made to bring speakers in and that money was received on the party. But when you look at the books, more money came in from Mackinac Island than was spent. But yes, there is some leftover debt, and that comes from some of the initial decisions run by the budget committee related to early staff. However, the Cromwell administration has raised more money than the Cromwell administration has spent, and we're left with this legacy debt issue. So now we get to the point that CoAmerica forces our hand after discussions with Jim Kopis, where they were cooperating and sharing documents. There was a decision made by CoAmerica to issue a letter of default, which seemed to hit the newspaper prior to my inbox. But regardless, the situation occurred where we were served with a notice of default. Our response after doing a significant amount of research on this notice of default was that they were targeting the building. So one of the things that CoAmerica had turned over to us was the title search and the records of why they relied upon the fact that the Michigan Republican Party owned the building. And in their title search, they turned over some documents. So we received documents from the bank file. Now, mind you, early on, Chair Karamo had been told that the assets were not trusted to be controlled by the state committee, so that in the wise and benevolent elitist previous people, they had chosen to form two trusts. One trust to own the data and to control the fundraising list. And they bequeathed us in a nice letter from Mr. Doster a list of addresses and names who had previously donated to the party without email addresses, and said that they were being cooperative and they did not have to do that. And that was how they had the data, including the fact that we did not get access to employment data, insurance data, or anything else. Because the data trust, they do not trust you as grassroots people to elect a state committee and to be able to access your data. They have removed that to a group of former chairpersons who sit around a room and determine whether or not you have access to your data. Secondly, they did the same thing with the building, or attempted to. So what you need to understand is the building at Seymour Street was deeded to an LLC called Seymour Street in approximately 2006. This is laid out in the lawsuit. And when it was deeded over there, it was actually a transfer in exchange for money from the Lansing Community College. So anyways, the community college had transferred this over for value, and there was a transaction to the Seymour Street LLC. Now, anybody who is aware of corporate documents, a limited liability company has what is called articles of organization, which are filed with the state that says, this is who Seymour Street LLC is, and here is the registered agent. They have an unfiled document called an operating agreement that defines how that is controlled. The first amended operating agreement was filed subsequent to that, which basically leaves us some clues and is attached to the lawsuit. But in general, it went like this. Because the Michigan Republican Party is an unaffiliated organization, is an unincorporated organization, the party cannot own real estate. And therefore, we as this trust are taking over control of the real estate, and it's been transferred over by the chairperson to this trust. So we have a problem factually, and that's why we sought declaratory relief. We didn't sue any Republicans. What we did was we said we have an issue with that. Because now that the Seymour Street LLC owns the real estate, the question is who owns Seymour Street LLC? Because originally it was the Michigan Republican Party, an unincorporated organization. Now you have this trust who has just asserted that it was transferred to them, and it's signed off by a chairperson. not accompanied by any resolutions or meetings or any indications that this was the will of the party. However, let's be a little bit even clearer. There seems to be a lack of communication to the bank because the bank thinks that the party owns it. And what's even crazier, Ron Weiser's financial statements from 2022 at year end, which listed as an asset, which was depreciated by the party, seems to indicate the building was owned by the party too. So on one hand, we have the trust asserting that they own Seymour Street LLC. And on the other hand, there's a bunch of evidence that says that it belongs to you, the people. So now the question becomes is, why isn't Chair Karamo using the building? Well, at the time that the party came into administration during the transition team, we had asked for the building, the information on that, and they wanted us to lease the building and pay the trust for the use of the building. The building is outdated and oversized. Chair Karamo had made the fiscal decision that it was less expensive and more professional and would save the party money instead of leasing from Seymour Street LLC without any clear records of ownership. She chose to move the state headquarters to a nice professional building on right downtown, across from the Capitol, just downtown, where the building now resides, for less than a third of the expense that we were asked to incur to have the big building that needed a lot of, shall we say, upkeep and deferred maintenance, was expensive to maintain. So this was before we were aware of this title shift, which predated my involvement with the Republican Party. Sometime around 2011, this is alleged to have occurred. So this would have been like 9 years ago that the ownership of the trust was asserted in a filing into the Register of Deeds. So now we have a situation from a legal perspective that I'm trying to unravel. Nobody wants to share documents except CoAmerica. And Chair Karamo actually was with me going to the title company, asking for information. And we were told that even though we were part of the title file, they would not share title records with us, which was kind of suspicious on itself. And so we are left with the records and documents which are attached to the lawsuit, which we've sought clarity on. So what has happened is the general counsel for the party from 1989, he was assistant counsel till 92, a man named Eric Doster. From 1992 all the way through 2017 was general counsel. He is listed as the representative, as the registered agent for the Michigan Republican Party Trust. Now, what's even more confusing, and if you read the lawsuit, you will see this, that the Seymour Street LLC files a series of corporate doing businesses as, and they, Seymour Street LLC, not you grassroots voters, not you grassroots delegates, have claimed the ownership to the name Michigan Republican Party, Michigan Republican Central Committee, and a variety of other names, the Republican Party of Michigan. So what is really interesting is that the fact that we are filing corporate documents with the Federal Election Commission and with the state document that says we as a state committee are the Michigan Republican Party, but yet you have the Seymour Street LLC is claiming to have the rights to use the name of the Michigan Republican Party. So when I say, well, how do we resolve this? I look to the statute, which is pretty clear, which I've set forward, which is MCL 169-211, which says we are not an unincorporated organization at all. We are, in fact, have a different status. That means that I can also be a male and a father and an attorney. Those are three different titles. So we have rights as a political committee. We have rights that are delegated to us through the Republican National Committee to be organized as a state Republican Party. So that is rights in contract with the National Republican Party. And we also have a statutory recognition of that conferring of power from the Republican Party, which is in there which says we are a political committee. We have the exclusive right as a group through representative government to determine who uses the name Republican. So now we have the Seymour Street LLC, which claims that instead of being administered by the state party, it's administered by a group of former chairs. And obviously there's a conflict between that. Do these former elites who controlled the party, or do the grassroots own the assets? And now, by the way, we did not sue the data trust. We only sued to ask for clarification about who, in fact, owns the Seymour Street. Now, I have not, by the way, as an attorney, I've been using the P.O. Box since 1998, which by my count is 26 years. I've never had a problem receiving legal correspondence there. But Mr. Doster, in his response, apparently has filed a motion or an answer in response to our pleadings, which I have yet to receive service on. We have attempted to receive that from the court. Apparently, it's been leaked to the news or provided to the press. And I have an email that says, we didn't want to send it to your P.O. Box. I wanted to FedEx it, but you don't have a physical address listed in the Bar Journal. Would you accept it by email? Of course, I said sure, and I have not received a copy of the lawsuit. Now, that doesn't mean I'm not aware of the contents, but this is me coming back from vacation. There is a motion which people are excited about because he claims our request to clarify why Ron Weiser had listed on his tax returns and depreciated the building under the Michigan Republican Party, why I think I'm a representative officer, general counsel of the Michigan Republican Party, but there's a DBA that a trust claims ownership of that supposedly owns the name the Michigan Republican Party. I sought declaratory relief from a court. And by the way, declaratory relief is to ask the court, using its Article 3 powers to resolve a good faith dispute between not an intra-party issue, but between a political party and an outside entity, which is a trust, that the only thing that they share with us is they have used the name Republican, and they may vote as Republican, and they may formally have held positions as officers. But it is not a delegate who elects a county delegates who elect people to go to state convention that select a state committee to represent them that is in control of this building asset or even the name. So Chair Karamo and I myself felt we had a duty to ask the court to clarify, because if the Michigan Republican Party is Seymour Street, the debt is in the name of the Michigan Republican Party. So they can't claim that the debt is ours, but yet they own the name when the name is in the name of the debt. And so there were certain things that we asked. We asked for the court to declare that we were the exclusive right to use the name, the Republican Party of Michigan, the Michigan Republican Party, the Michigan Republican State Committee, and that is through the elected process of the grassroots, not the ownership of a trust set up by former chairpersons. We asked to clarify who owns, in fact, the Seymour Street and whether this transfer was valid. And third, in all my years of looking at commercial debt, I've never seen a $3 million promissory note that's signed by a person who is, his signature says he's an officer of the company, but it's not witnessed and it's not accompanied by any corporate documents or resolutions. So I asked, is this debt legitimate and valid? Because it's been represented that it's a legitimate debt by CoAmerica, and they've sought default. They have sought to attach assets of the Republican Party of Michigan, which is the state committee, which is money that has been raised through the efforts of the administration. But yet, there's this issue, and anybody who claims that a declaratory relief action to ask the judge to determine interest in the ownership of the intellectual property of name, to determine whether the debt is valid, and to determine the ownership when there's a good faith dispute, it is not a frivolous claim. And quite candidly, I know the budget committee didn't vote to do this, this is my responsibility as a fiduciary duty as general counsel to pursue and to seek clarity, because the records that I have received are inconsistent. And while it sounds like Michigan is fighting, we are in a battle of grassroots versus the establishment. And you need to make a call and ask yourself, why is there so much pressure to withdraw this lawsuit? The reality is if you do not believe that as a state party, you have the responsibility and authority to go as delegates and to elect a chairperson and officers, and they will act in the best interest of the of protecting your data and your assets, then we have significant problems. Myself, after checking with the people that I work with very closely, I made the determination that the lawsuit needed to be filed. And Chair Karamo deferred to my judgment. And I feel that the declaratory relief to clarify these issues needs to happen. And by the way, before a case is ultimately decided, there is a process that normally occurs called discovery. During that discovery, there's depositions, there's requests to produce, there's written interrogatories, and we will be able to, through the discovery process, obtain the rest of the picture. However, the bank tells me that this is an asset that is negatively pledged to the loan. The bank tells me that it's in the name of the Michigan Republican Party, which is us, we the people who are currently in control of the administration. And yet there's this trust who claims they own the name, the real estate, and a second trust controlled by the same people with the same registered agent who says they also own the data. So that is the situation behind the lawsuit. Now I would like to turn to the next issue. And I got to apologize. My screen went to sleep because I know I'm doing a run on discussion. And I apologize after my opening remarks, which I hope will answer some questions, but I know from experience will cause others. We will begin answering questions. Right. So I have the lawsuit, which, by the way, not only myself and others looked at very carefully. The investigation was done very carefully. It is, I think, 96 or 97 pages long with attachments. And CoAmerica has indicated that they have accepted service and will respond on January 10th. Okay, so the fourth thing that I want to review today, which I've gotten a ton of emails about, is the process for calling a meeting. Our bylaws are extremely clear that the chair calls the meeting, not the co-chair, not a group of delegates. They have a right to request a meeting, and in response, Christina did call a meeting, not for this Saturday, tomorrow, but for the following Saturday. That meeting was called by the chair. So what appears to have happened is somebody has misappropriated MyGov letterhead and issued an indication for a call for a meeting tomorrow. That is not proper. Now, as far as the procedures for the removal or discipline of officers, I want to be clear here. 2,500 delegates elected Christina Karamo by about 13 points at a convention. The state committee, which is a representative group, does not get to easily thwart that election by the delegates at a convention of delegates. So the bylaws say that before they can even bring up this to debate, they have to get 50% of the state party and submit that to the secretary. That has not occurred. However, since before Mackinac, actually almost from the beginning, people have been asking to remove Christina and been saying that we need to have no confidence in her decisions. Now, I can go through the merits of whether or not she's made good decisions or not and argue that with anybody all day. But the reality is the process for overturning an election of a convention of delegates begins with 50% of the state committee signing a petition and filing it with the secretary. The secretary, I believe, is on here today. she has not received a request for removal of discipline of officers. By the way, I was voted in by the state committee, unlike Christina Caramo. I was actually voted in unanimously by the state committee as general counsel. It is a thankless and unpaid position, but I'm happy to do that, and I will do it the best of my ability. Christina, on the other hand, was voted in by the convention of delegates. But regardless, the removal provision is the same. My understanding is it would require 54 signatures for a vote. After the vote, you need 75%, which would be 81. They know that they can continually raise this issue as they have done before Mackinac, the detractors, but they do not have the votes to get to removal. But yet that becomes the topic. And then they say, oh, Christina's ineffective in fundraising. Well, from day one, people have said she's not qualified. She was attacked like Trump from day one. Impeachment inquiries over and over and over again, which is a strategy to make sure that when she goes and talks to the big donors, who in all candor do not want the grassroots to have representation in the party. They want the status quo. So this is a process for removal. And I have indicated that if there is a 54 signatures, I won't even require myself to go to a vote. If you have 54 signatures of state party members that you think that there should be a vote on my removal, on that day I will tender my resignation. I'll be happy to go. If I don't have 50% support, I'm not interested in doing the job. That being said, Chair Caramo was not elected by state committee. I was. The state committee delegates that were elected through county conventions have the right for her to stick in there and do her job until the provisions of our bylaws allow for her removal. A state committee should not be able to easily overturn the will of the convention. Now, there is another process for removal under conflict of interest within the bylaws. And in my legal opinion, there are certain members of state committee who have violated the conflict of interest rule process. That process has not been started, but I will assure you that the best interest as a fiduciary of the Michigan Republican Party is not served by trying to tear down the leader who is, in all candor, doing an effective job with the resources. As my friend Ken Byer once stated, you can't fire the establishment and then be surprised when they don't write the checks to run through the party. But let's be clear here for all of you who are concerned from a grassroots level. In the past, money has flown into the party and it has gone out to the candidates that were handpicked by the administration. My friend Mark Fortin once told me in Macomb County that whenever a grassroots candidate rose up in Macomb County, that the former administration would not only send interns, but would send money to compete with the grassroots candidate. When money comes into the party and the people in control of the party use that to squash grassroots candidates, you do not have representative bottom-up leadership. Chair Caramo is not going to do that, but yet she hasn't received the big chunks of money to influence how politicians will vote. Because guess what? Former Governor Rick Schneider, I've seen the video of him, has directed people to donate not to the party, but to the House caucus, for example, I believe it was. It's been some time since I referred to it. And other people have decided to raise money and give it directly to the candidates, not through the party. Well, ultimately, that is their right to do so. But the party, which is focused on administering the process, attacking election integrity issues, which we're doing, and doing these other processes, should not be in the process of selecting grassroots candidates. And that's something that hasn't happened during this administration. Topic number 5, the unincorporated association versus a political committee. Once again, I've mentioned to you I've given you the sites in the agenda that went around, 169, 211, 600, 735, and 600, 2051 are some statutes that people have asked some questions about. As far as unincorporated associations versus political committees, yes, an association of people does not have to be filed as a corporation. I want to explain to you some general rules. In law school, we learned very simply, even though it was, 30 years ago, I'm very clear that common law for a general partner was you are responsible for the acts of your general partner. So that's why they created corporations and limited liability companies, limited partnerships, and other legally created means to get around that general common law rule. An unincorporated association would be like a housing association that hasn't filed its paperwork. Yes, you can say that we are not incorporated and therefore we're not an association, but on the other hand, the Seymour Street LLC is a limited liability company filed with Licensing Regulatory Act and claims to be doing business as the Michigan Republican Party. It is very hard for me to look at financial records and legal documents and to separate the two. So that is the very, very first issue. So there's also the statutes, which I've included, 600, 735, and I know Joe Welch had sent me a concern of one of the comments that was circled in a brief about the fact that individuals in an unincorporated association can sue and be sued. Well, that is capacity to sue. That is not liability. And the question of individual liability is another and separate, distinct issue. I'm not going to get into that lengthy legal argument, but the fact that there is fear-mongering that as a result of me filing a lawsuit, it is frivolous, meaning that there's no good faith basis to go forward. By the way, I have a second and third opinion with legal counsel before I filed that lawsuit. I did not do this unilaterally or as a whim. And secondly, whether that means it is going to result in an individual state committee member being penalized, that is a fear tactic because they do not want, at the end of the day, the grassroots in control of the data to raise funds or to administer this party or to control real estate assets. So those are the comments that I wanted to tell you. And at this point, what I'm going to do is I know that other members of the team have been reading and taking notes of your questions and comments. One of the ones that I'm aware of is that you may have 53 signatures to remove me, and if you have signed that and you wish to have me removed, that's great. If your signature's on there and you do not wish to have me removed, you better let them know, because I will tell you that at the end of the day, as a volunteer, I have promised to Chair Karamo that I will not leave her on the battlefield. I will stay here and fight next to her. But I believe that there's a major distinction between my role as general counsel and her role in the way that we were elected. That being said, if out of the 108 active state committee members and officers that are entitled to vote, that I lack confidence in by a majority of them, my time will be done. That being said, let us now open ourselves to questions. And I know that Lori, who has been moderating this, has been carefully noting your questions. And you can either read them back to me or phrase them. And we will answer questions from now until you guys get tired of asking me questions or we hit midnight.
Thank you. There is a question from Mr. Rawardink, and he would like you to address why do you make donations to Democrats over the past years? Excellent
question. So when I was first out of law school, I voted independently. I voted both sides of the ballot. This is a long time before the Democratic Party shifted and before I became a Christian. And I feel that the values of the Democratic Party do not align with mine. So the sole donation that I made was a donation to Jonathan Edwards, who ran in early 2000. After I had graduated from law school, a good friend of mine, Orville Lee Hamilton, who's a Republican now, out of Alabama had contacted me and asked me to donate to Jonathan Edwards' campaign. And at that time, I was a trial lawyer. I had no problem, and I made a contribution. By the way, the Republican Party has embraced a lot of former Democrats and people who have been with different political ideologies, and it should. The reality is do I subscribe to the Republican platform now? Yes. Nobody has checked the number of contributions that I made during Trump when I was led to believe that he was going to do something to fight election integrity at the end of his campaign. And the RNC raised a significant number of money. I wrote on an RNC ballot before I decided to get involved and change this after a great deal of prayer. I wrote a letter to the RNC and I said, listen, I'd like you to refund my money because you did not show up on the battlefield of election integrity, of which I was engaged in since 2000 forward. Why did I get involved and run for a precinct delegate in Emmett County in 2022? Quite candidly, because I recognize that the core responsibility of the Republican Party is to make sure the election process and election integrity exists. And I will tell you that as Republicans in the state of Michigan, from a county grassroots level on up, we have failed to make sure our election integrity processes are there. Nobody can change the fact that my vacant piece of property cast an in-person vote by a person who hasn't lived here in more than 10 years from a vacant building, and that is on the voting roll for 2020. And that's why I got off the couch. That is why I became a red grassroots Republican, and I am not ashamed of the fact that I have participated in the political process in early 2000s to support another trial lawyer, Jonathan Edwards, in his pre-presidential primary run. So that would be the answer to the question.
Okay, thank you. Does the ACLU know that you are taking credit for their work?
The ACLU is not the entity. It's the American Center for Law and Justice. I did not take credit for their work. I worked with the attorney that was assigned to the case, a man named Ben Cisney. If you would like, we can bring him up on. I have prayed with the man. I have talked to the man. We have strategized. They wrote the brief, but I was involved in not only the legal strategy, but I was actually the representative at the oral arguments, and I have been involved very closely, along with Chair Karamo, in not only strategy formation, but in ultimately, I'm the guy who signed the brief, which means that I never attributed the work product as my own, but I was the person who signed, subject to the sanctions as to whether or not it is a meritorious action. My office filed each of the documents. I was a small cog in the wheel. Quite candidly, the person who deserves the recognition is Chair Karamo, who, along with the American the American Center for Law and Justice, was the one who built the coalition of other chairs, and ultimately the Heidemus Doctrine in the issue of the political party having the exclusive right had to be asserted by a political party, and that is what we asserted on behalf of the Michigan Republican Party. By the way, the RNC was not present at either the Court of Claims or the Court of Appeals. They got involved when it went to the Michigan Supreme Court.
Okay, thank you. How much time, effort, and money was spent by MIGOP to, quote, support the Royal Oak recount?
Well, I'm not aware of any money that was spent. I can tell you that volunteer times, I volunteer at my church, I volunteer at a homeless shelter, I run a Bible study. My rights are not exclusive, but I will tell you that members of the administration volunteered their time to go to the Royal Oak recount, to do research, to strategize, to talk about legal issues, and to review the records. For those of you who are not aware about what happened in Royal Oak, there are verified people who not only, which has been happening since 2020, they have returned a ballot, some by dropping it off, some by mailing it, and some by putting it into the hand of a clerk, and they are recorded as not having voted in the 2023 November election. If that doesn't concern you in a close election, when you as a Republican entity are responsible for the administration of one half of the processes to check it, and then during that recount, volunteers which were mobilized to scrutinize the recount identified the fact that there were bags, once again, that were not sealed, were not recountable, that the ballot numbers did not match, there were violations of election law, and our Republican canvassers, along with the Democratic canvassers, who have a statutory duty under MCL 168-865 to investigate this and to make a report, abdicated their responsibilities. I did not volunteer in a capacity to be a lawyer. I did not sign on as the Michigan Republican Party, but I also was not forbidden by Chair Karamo from appearing in a divorce trial for 3 hours this afternoon. So I can do what I would like with my time. It was a concerted effort from a bunch of people who care about whether the grassroots voice is being heard in the ballot box. But I'm not aware of any money being spent by the party. And by the way, I did not charge them for my time to talk to 5 or 6 other lawyers and to strategize. And I'm not taking credit for the work that they've done either. I will tell you that Republicans who care about elections were on the street knocking on doors and verifying the facts of what I've already told you.
There's more questions regarding the elections. Since we're on that topic, I'll just put that in there. How many EI lawsuits have you been affiliated with, election integrity specifically? And can you give a little bit of background with TCF, your work that you did like in 2020 or in 2022 with election integrity? There seems to be a lot of questions regarding your background in election integrity lawsuits and work.
Okay, I never read the election code until 2020. At some point in 2020, I ended up getting a copy of the qualified voter file, and I was horrified to find that under the rules, my mother, who had left the state in 1996, was a registered eligible voter in Dickinson County, the same area that Ed McBroom is from. I also found both of my brothers who had lived in other states, Iowa, South Carolina, Wisconsin, that are all Eric states, which were still listed as eligible voters. Now, they had a verified tag, which means that they had not been inside a Secretary of State office since 2020. Upon further scrutiny and review, knowing that they did not live there, I was able to discover that Jocelyn Benson had inserted 600,000 plus driver's license record information of eligible voters, and she added them to the QVF. For those of you who are involved at a township or municipal election clerk process, your name in the QVF means that you are presumed able to vote. When you are in verified status, means that they have never captured your signature, and they have to capture your signature. Well, we have tracked records where people came out of unverified status by the tens of thousands right before the election and then returned. I will not even go into the lengths that I went as a cynic. By the way, when I read my Bible, I read it as a cynic, as a criminal defense lawyer that says, prove it to me. And I'm going to tell you that I was satisfied with that proof, and I am satisfied to this day. When I started looking at election integrity, I did not believe what I would find. I found in Leelanau County that there were more votes than there are registered voters in one of the precincts. I followed the Antrim County stuff really, really closely, but I was not involved. What I was doing was I got my own qualified voter, and I just checked the real estate that I owned, my family members, and people I know. I found a guy who I had gone to his funeral when I was 14 years old in a voter roll in Sheboygan. That's all stuff that you cannot tell me that there's not problems with the election system. So I got involved. I've never worked for EIF, although I have collaborated with EIF. I've remained independent. I've gone to Mike Lindell's symposium in Branson, Missouri, and I have read voraciously. I consider myself a friend of the Raccoon and Draza, who I've spent hours on the phone discussing. I've been active in Telegram chats. I was involved in filing a lawsuit in the federal court, which challenged under the, it challenged basically because whether people have taken the time to read the Help American Vote Act and who have read the VVSG version 1, 1.1 or 2.0, any of those VVSGs, which are the voluntary voting standards. I have read the Michigan documents and the state plan that's been filed under HAVA. I've read the election code, which requires accuracy standards, which were not met in the election that just recently happened in 2023 in Oakland County, which has a defined federal standard for how many times a tabulator can make an error, what percentage is. And I was horrified to learn that the machines were not properly certified by an accredited agency in Michigan, but yet they ran the 2020 election. So on behalf of the Americas Project and others, I filed an action along with a variety of other people, including Christina Cromwell in the Western District. And that case, of course, went nowhere. I was involved in a HAVA complaint with Eric Cardell, who's an election integrity attorney who is currently doing great work in Michigan, that was later withdrawn. We were part of letters. I represented Mark Fortin down in Macomb County. I represented Donna Brandenburg when she was removed from the ballot in her petition to the Supreme Court, and ultimately into federal court. But when she went on the third-party ballot and was on the ballot, it mooted out the case and we withdrew that. I was involved in what I would say is tackling Detroit, where we put on a person who has administered Michigan elections until he became a consultant. And I'm not going to get into the names and the details of that, but in Oakland County, in Wayne County, we filed a lawsuit. And it was held by the judge to have been barred by the statute, the Latches statute, because it was too close to the election at the time we filed it. Well, regardless to say, Alexandria Taylor, who's one of the Senate candidates, joined me in that lawsuit. And as a result, the judge issued a sanction and said that our matter was frivolous. It's not frivolous. That's on appeal at the Court of Appeals. Interestingly enough, some of the things that we asked for the judge to make determinations on, such as to require that the city of Detroit comply with the posting requirements in MCL 168-765, they did not comply with. And many of the things that we predicted in that lawsuit would happen if the judge did not issue relief came true. And needless to say, it was a very, very hostile environment. Those of you who watched the hearing will see that there was some issues in the case. Regardless, that case is still being litigated, and that case is still pending. I have consulted on many election integrity cases that are even outside the borders of Michigan, where I have provided evidence and information and research. And quite candidly, election integrity is the reason that I chose to get involved in the Republican Party at a grassroots level. When you talk to somebody who claims that they are grassroots, ask them what they're passionate about. One of the things that I use as a benchmark to see if somebody's really grassroots is, do you care about elections? And that is my issue.
Thank you. Can you explain why was we're not using the building? I think what they're asking is, if you can explain why we did not use the Lansing headquarters.
Okay, I was part of the transition team. This was before I agreed to be general counsel. I went down there because I was asked by Chair Karamo. We showed up with, Joel was there, myself was there. I would say there was probably 7 people there. We had people ready to learn about employment. We were ready to look at everything. We walked into a building that had been gutted and cleaned out. There wasn't a working telephone. There was some desks. There was some boxes. There was no computers. There was nothing handed over. And I kid you not, if you've ever seen the scene in Good Will Hunting where Ben Affleck goes to replace Matt Damon, we walked into a very casual Paul Cordes who said he had about 45 minutes. He made representations to us about the transition, said he had a hard deadline. We walked through the building and it was a mess. It would have been extremely expensive to furnish the place. There was tons of deferred maintenance. At the time that building had formerly been used, they had staff and phones ringing that we knew we were never going to need that much staff. And more importantly, they put a price tag on it that was, you guys complain about the benefits of Jim, not you guys, but some people are complaining about the benefits of Jim Caviezel. Well, the use of that building would have exceeded, in all candor, we would be raising money to pay for the building to the trust had Christina blindly accepted what they wanted for a lease for a building that is later turns out when we recover financial records, it's listed as an asset of the party. We would have been paying this trust a deed. Her instincts were right. She said she could get a nice new modern space. And currently a lot of the party and officials, she was trying to build a coalition from the west, the north. I'm from the north, from the east. And she knew that a lot of the meetings would be virtual post-COVID. So she made a great leadership decision and abandoned an expensive, outdated asset that needed a lot of cost and maintenance. Oh, by the way, I voted against it. I urged her to stick with the building. Matter of fact, I said, I want to go on the record, you're wrong. Well, guess what? She was right. I argued vigorously and then execute faithfully. Her instincts were right. I was wrong, and it has been proven out that she made the right choice.
How busy is Christina with unauthorized?
You know, interestingly enough, I don't know what Christina does when she's not working for the MyGop, but I will tell you that I know that this woman, I'm on the phone with her 1 o'clock at night. She gets up, lives, sleeps, and breathes. This unauthorized is a passion that Christina and I are both aware of. We are aware that they are doing election integrity. Christina has gone around to more Lincoln dinners for county committees to help them raise money. She came up here to the 1st District. She has been all over the state trying to make sure that the message of election integrity is not dropped. During the discussion of running for Secretary of State, she was basically told you need to drop election integrity. The other candidate for Attorney General chose to do that. And that's the reason when we came to the chair race, a lot of people chose to choose Christina because people do care about election integrity. The establishment doesn't. They pretend like it's fake news and not a real issue. So that group is about making sure that there is election integrity to the best of my understanding. But I can attest to you that Christina puts in her 100 to 120 hours easily. And Lori, I know you've probably been on the phone with her more than 100 hours this week. So I don't know how she has time for her children. I don't know how she has time for her church. But yet at the same time, this is a job which she has not been taking compensation for, but yet she is leaving it all on the field for you. So if she's involved in another entity about election integrity, I applaud her for it, and I think that is a compliment, not a negative or a detractor. By the way, when she has agreed to be the chair, you do not judge a chair based upon how much they fundraise. We have a finance chair who is responsible for fundraising. We have other different responsibilities, and the people who level the criticism are people who have not made contributions to the party, either in time or in money. And so what I would tell you is Chair Karamo has put more than her fair share of hours into the promotion of the best interests of MyGov. Lori?
Yep, sorry. I do have the chairwoman, Madam Chair, if you would like to speak to that, since that question was directly related to you, you have the floor.
Yeah, so I don't spend any of my time in unauthorized. That's why I resigned. Just some background. So back in 2021, I joined a group called the Candidate Coalition. It was a bunch of America First people who were running for the office of Secretary of State. So like Mark Fincham out of Arizona, Jim Rashant from Nevada, Andrea Trullo from New Mexico, Rachel Ham from California, Diego Morales from Indiana, a lot of people, even other people like Doug Mastriano, who's running for governor of Pennsylvania, because in Pennsylvania, the governor appoints the Secretary of State. So we have an election integrity group, and we meet regularly, and we have formed a very tight bond because our focus is cleaning up the elections. That is our goal. Out of that group, we decided that, and some of us decided that it may be a good idea to start up a 501c4, because this is something that Democrats frequently do, and this is one of the reasons they beat us mercilessly. They start 501c3s and 501c4s, and these organizations function as opportunities for them to do work and go into spaces that the political parties have a harder time entering into. So a 501c4 is a nonpartisan organization. It serves the purpose of education and social welfare, and our focus was purely election integrity and constitutionalism. So I'm not sure why it's a controversy. I know that someone took an out-of-context interview from flyover conservatives, and I'm not trying to be condescending to the person who asked the question, because it is a legitimate question, and I appreciate that. But the show our executive director of Unauthorized is on, it's called Flyover Conservatives, yet we are being accused of being Democrats. So the show, Flyover Conservatives, he was talking about the unauthorized effort to really educate the public about election integrity. So some of the things that Unauthorized funded look like the Hand Count Road Show and other forums throughout America, because our group, starting in 2021, before Unauthorized was founded, that's what we did. Oftentimes I would travel to other states. It was very beneficial to build those relationships and to build those coalitions, and especially as grassroots Republicans, one of the things our power is in our people. So we really work hard to strategize with other, America First Republicans across America on strategy to clean up our election system. So that's what Unauthorized is all about. However, directly to how much time I spend, none. That's why I resigned, because I don't have the time. I never got paid. It was never any intention on getting paid. It was purely a volunteer effort, just as though many of us are involved in multiple organizations. But I simply don't have the time, so that's why I had to bow out of it.
Thank you, Madam Chair. And I would just like to say that this is a perfect time to thank all the people that have dedicated so much. This team works 7 days a week, from the early morning till late at night, every single day of the week. So the only way that she could be doing another job is if she has an 8th or 9th day of the week. I appreciate all of the text messages and emails of so many of you that are on here tonight with your support. Please know, too, that if you're not getting a response, it isn't because we aren't getting them. We are seeing them. We are just been very focused trying to do the work of the party. So I will be emailing you all back and texting you. Thank you for your love and support and your wishes and prayers for us every single day. With that, the next question is back to you, Dan. What role does Mike LaBadie play in MyGov? And since he's the top advisor and not elected, shouldn't his bio be on the website?
Well, what's interesting is Mike is a guy of great insight and wisdom. I like talking to him. I can honestly tell you that I have probably not talked to him it's definitely been probably 1 or 2 times since Thanksgiving. To the extent that he is a top advisor, He is one of many people. We receive input and feedback from all types of different people. But what I will share with you is that I would like to think that I'm an advisor to Chair Karamo, but she is a woman who makes her own decisions based upon multiple sources of information. I've given you the example, and I don't want to, out of disloyalty, tell you about other choices that I've vigorously argued and executed faithfully on, which is a loyalty pledge. When you go on a ballot with somebody or when you are part of an administration, you're loyal. You don't start signing petitions for removal and doing different things as part of an administration. But nevertheless, what I will just say is I've given the example of how I opposed Christina's decision vigorously and wholeheartedly on the building. She had multiple sources of consultation and she made the right decision. And that is her responsibility. What I will share with you is that Mike Labadie, when I met him, was a precinct delegate. He was involved in Chair Karamo's campaign. He doesn't even work in the state most time. He has been part of conversations and he's been asked questions. But anybody who doesn't think that Chair Karamo is in control of the decisions and making the parties, or that she is a puppet, I've heard that she's my puppet. And I find that laughable. She is a powerful, smart, intelligent, articulate leader who I have kneeled and pledged fidelity to and given her my sword. And a lot of other strong, intelligent people have done so as well. So Mike Labadie is a question that is a distraction. But what has Mike Labadie ever done against the Republican Party? There isn't anything. People say I've heard all kinds of stories about who he is and what he is. What I will tell you is he is a person who is concerned with the outcome of elections in Michigan. Election integrity is an issue that's very near and dear to his heart. And yes, he is a person that I consider a friend, and I will not step away from that.
Okay, thank you. If the majority of the state committee on January 13th votes and directs that the lawsuit against the trust and Comerica should be withdrawn, will you and the chair take that direction?
You know what? From my personal perspective, if the majority of people do not want to pursue the lawsuit, I will feel I have done my fiduciary duty. But ultimately, what I'm going to tell you is the state committee is not who Christina was elected by. And I'm sorry to tell you that. She was elected to run the state committee by the 2,500 delegates at convention. So it is ultimately Chair Karamo's decision, not the state committee. There is a misperception from people who have not read the bylaws. When she forms subcommittees, they are subcommittees that are to provide her advice and consent. She has a fiduciary duty to do what is in the best interest of the people who elected her. And I cannot see how would be considered in the best interest of the party to withdraw the lawsuit. But on the other hand, I will withdraw the lawsuit when Chair Karamo tells me to, not based upon a vote of the state committee, because Chair Karamo was elected by the delegates.
Okay, thank you. When will field staff be on the ground to help our candidates identify voters and build infrastructure to turn out voters? I think they're referring to RNC field staff. Okay,
so, and I would tell you that there are several pieces of election integrity that we are working on. One of those pieces is the fact that we have to watch the processes, we have to train people to watch the processes, and we have to deal with election integrity. As far as being involved in assisting candidates in campaigns, one of the beautiful changes that occurred in the December 2022 versions of the bylaws is that the state party cannot get involved in supporting candidates prior to the primary. So the reality is that was a major shift in the party. And I know that people who are grassroots people that I can argue with, such as Mr. Forden, would agree with the fact that the state party should not be selecting candidates and sending interns from the RNC prior to the candidates being determined who are going to wear the R and who are going to represent us in the general election. That is one of the very things that I listen to, not just to Mark Fortin, but to the rather large following that would go to court and would talk about their concerns about the way the Weiser administration was administering the party. And one of the reasons why at one point Mr. Fortin did support the Karamo administration. And this is something that I have not abandoned. Even though Mark and I haven't been close and we've had our disagreements, I believe his read on this is direct fastball down the middle. I think that those RNC support should come to represent the delegates that have been selected after the primary process, and that the state party should not be affecting what is going on at the primary. It has to be equal for all and not playing favorites. That's my personal opinion. But by the way, that is outside the zone of my responsibility of general counsel. But thank you for giving me a chance to pontificate.
Yes. The next question relates to Kalamazoo. Where is the Kalamazoo County chair on MyGOP's website? Sorry, go ahead.
Yeah, so here is what's really interesting. I'm going to just say a couple of things here related to the Kalamazoo controversy. What I will tell you is I'm not going to go back and plow earth. I mean, I've been accused of being heavy-handed because I tried to mediate a dispute. But because of the way the bylaws are written, I tried to get the policy committee. I all but gave them. I went through on behalf and direction of Chair Karamo, another sign of leadership. She had me survey all 50 state Republican bylaws. I also looked at several Democratic sets of bylaws. And I went through and I looked at all the different ways that delegates were removed, state committee members were removed, officers were removed, and the way conflicts were resolved at county and district policies. And would you believe that there are probably 20 different ways that they do that around the state? And I prepared that and I provided that to the policy committee. Jim Kopis, he's nobody I knew before this process of fighting in a foxhole next to him. Him and I got in a car and drove all the way down to Muskegon County to meet with Melissa, Andy, and Greg to go through this. We spent 4 hours in the car for a 45-minute meeting at which I presented them all the bylaws, all the rules, and we were hoping to try to get a process in place where the policy committee would make recommendations for dispute resolution in an elected process. We also tried to get that through the conflict resolution committee, which was a chair that Chair Karamo had set up. But ultimately, without an amendment of the bylaws, the state committee, once again, my dear friend Mark told me that the state committee should not be interfering in county party politics. And to a large degree, as a person who believes in Republican principles and government should be local, and talking to Joel in Ottawa and Ken in Allegan and other people, I have come to say that basically the state should not, the delegate is the power of this party, not the former chairs. And there's a tipping point there where you, as a group of delegates, form a county, and a group of counties send delegates to a state convention, and you elect a leader for the state like Chair Karamo was. I understand all that process. But should Chair Karamo be getting involved in trying to decide who is right in Macomb County, like which happened to Fortin, or who is right in Hillsdale, or who isn't right in Kalamazoo? So Hillsdale, we took the position that was resolved by the convention, and we weren't going to change it. And a judge has issued a civil contempt hearing, so Hillsdale was taken down. Kalamazoo is a different issue. Kalamazoo has had a convention of delegates which has elected a new party. We have not been asked to, as a state party, resolve that. And in all candor, the county party, the next involvement the state has with the county party will be after the primary election in 2024. And so is this a situation where we should recognize one of the two chairs that one that's been elected by the delegates now and one that's been elected by that, or weigh out or do that? And the answer is this is a county party issue. I know there was a lawsuit, and we're not being heavy-handed. We're not recognizing anybody at this point in that dispute. I think the delegates of the county have to resolve their own dispute until and when the state party is delegated that authority by the delegates or by a collection of the counties through the representative process of the state committee amending its bylaws for conflict resolution. My heavy-handedness has been non-intervention. And for those of you who like county politics and parties, Christina Caramo has not directed me or has chosen not to get involved in the many intra-party squabbles at a county committee level. That is not the mandate that she was elected to do. And I'm sorry that there are people on both sides of the issues. We listen to you, and my heart goes out to you, and I pray for peace and unity. But you can't have two different people who have a philosophically opposed result who will not sit down and resolve it. And it really isn't my role as general counsel to decide who the chair of Kalamazoo County is. I think that is the responsibility of the delegates.
Okay. Do you know about the criminal and financial backgrounds of many MyGov advisors and staffers? Do you do background checks on your admin and your advisors?
Okay, so let's start by asking, do we do background checks on precinct delegates? Do we do that on county chairpersons? Do we do that on district chairpersons? Do we do that on district committee people? And the answer is, what does somebody's background tell them? Now, I'm a person who has had to kneel, repent, and change my ways. The last perfect person we crucified. So listen, I judge you based on how you're interacting with me. I don't care what has gone on in your background. I have met some of the most wonderful people who have a really, really nasty record. That doesn't change things. One of my current friends spent 25 years in prison for second-degree murder. I'm not going to say he's not my friend. I pray with the man. What I will tell you is I'm not going to judge you based upon the mistakes of your past, or everybody would be disqualified from office. Are you going to jump in a foxhole? Are you going to deal with the time? Are you going to show up on Zoom calls? Are you going to try and figure out election integrity? Are you going to try and advance the interest of what a Republican Party is supposed to do? Then I will be there for you. But on the other hand, what I'm going to tell you is, if this is directed at Robert Owens and what Robert Owens went through in Ohio, Robert Owens acted as a gentleman during the time that he was participating in Mackinac Island. Robert Owens was a person who had contacts and friendships with many of the people who were speakers. And we were able to save a lot of money and put on one of the best political discussions. Unfortunately, that contract was signed through 2029 by an administration years before Caramo. And as a result, we were obligated to go to Mackinac Island, which was typically a lobbyist-infused party for the elected people that the grassroots couldn't afford to go to. Many state committee members, people from Charlevoix County who I love and respect, couldn't afford to go to the island and participate and stay at the Grand Hotel. But that's the contract that Chair Caramo inherited. But what I will tell you is I will tell you that there are some people who question Robert Owens' integrity that I would line up the two of them, and every single day I will stand next to Robert Owens and shake his hand. And I don't know who else that was done. I have not done a background check on other people. You can do a background check on me. You can do it on anything. It's easy to tear down. But my question is are you there when the matters step down and go forward? I personally believe in second chances, forgiveness, love, justice, and mercy. That's where I am. So no, I've never asked for background checks of somebody who's going to show up and volunteer and work and spend hours on the phone trying to elevate the party's business and judge them based on something that's happened in the past. Robert Owens was a person who put a lot of time and effort in to make this party better. And he has a lot of powerful friends who know the true story about who Robert Owens is And he has gone through a metamorphosis. He is a praying man and a believer of Christ.
Okay, thank you. I do think it's important too that, there is some background checks that do happen and Dan works on the legal side, so sometimes Dan's not in the admin side of this. If that question was directed at Robert Owens was a volunteer. Again, I did a background check in my role to work on the administration. And as far as I know, I passed. No one has fired me yet. I don't take a salary either. All of this is volunteer, but nonetheless, I did do, proper background checks to work inside the administration. That is a little bit different than the elected officials, so that everyone can make a distinction between a role that is an elected official versus a hired staffer, even though that hired staffer doesn't actually take any compensation. So there are background checks that happen inside of the administration, but it really depends on the level or the extent that you're working inside on a volunteer basis. I hope that clears that up a little bit. I think you answered this already, Dan. It wouldn't